Now, I am going to dictate a legal passage at the rate of 160 words per minute. 5, 4, 3, 2, 1. Start. Let's start. At the outset, it is of essence to assert in terms and conditions of the grantee the duty of the bank is created by this document itself. It is this document which defines the obligation of the parties ordinarily. The nature of the bank grantee can only be assessed from the terms thereof. In my view, the grantee is unconditional and unequivocal in nature and categorically mentions that the bank is obliged to pay on first demand without any demur, observation, context, recourse or protest and oblique or without any reference to the contractor, that is the petitioner. Thus, the liability of the bank is absolute and categorical. Hence, I reject the contention made on behalf of the petitioner that the demand for invocation or payment must clearly state what exact monies are payable by the petitioner. I reiterate that there is nothing in the express language of the grantee which makes it obligatory on the respondent number 1 to mention what monies are exactly payable by the petitioner. In fact, the letter of invocation dated 24th May 2021 clearly stipulates the invoked amount to be the extent of the guarantee. This, in my view, is sufficient compliance with the terms of the guarantee. Accordingly, I do not find any merit in the contention of the petitioner that the invocation of the bank guarantee by the respondent number 1 is bad fair. Once it is found that the bank guarantee is unconditional, irrevocable, it is not open to the bank or the principal debtor to raise any objection whatsoever to pay the amount under the guarantee. In my view, the respondent number 1 beneficiary in such circumstances in whose favor the guarantee is furnished cannot be prevented from the bank guarantee on the pretext that the letter of invocation must clearly state what nominees are payable by the contractor. I am also of the view that it is important that whilst adjudicating on the aspect of the bank guarantee, a court refrains from entering into the merits of the underlying contract between the parties until and unless the terms of the guarantee show provide. I am of the view that the disputes between the beneficiary and the party at whose instance the bank guarantee has been given are immaterial and of no consequence at this stage. I also do not find any merit in the contention of the petitioner that the letter of termination dated 24th May 2021 does not make any mention of the exact monies payable by the petitioner. There is no obligation at this stage of the proceeding to enter into the exact quantum of damages which may be ultimately found to be due and payable by the petitioner to the respondent number 1. Similarly, the obligation of the petitioner is successfully commissioning the work and the issuance of the commissioning certificate are all questions which would be gone into in the arbitration proceedings and pertain to the merits of the underlying contract by and between the parties. So all these issues are outside the arena of consideration of the question raised at this stage of the proceedings. Stop. Thank you. Jai Hind. Jai Veera Bharati.